Hello, my name is Robert Sterne, and I am a law partner at the law firm of Sterne Kessler, Goldstein Fox in Washington, D.C. I want to address the important topic of the whole new world that universities and technology centers face in the United States under the new America Invents Act, which became operational on September 16, 2011, with subsequent operational deadlines on September 16, 2012 and March 16, 2013. These new laws create an entirely new environment for universities and technology transfer offices. It's my experience that universities and tech transfer offices have not gotten on top of this new world in many important respects, and hence the need for this short video. I would submit that universities need a top-to-bottom review of these new laws to figure out how they impact on their business model of monetization of their critical R&D. And first, they need to examine how they are going to protect this R&D going forward. Historically, as we know, universities and tech transfer offices would wait to file the patent application until they had received significant commercial interest from some outside entity who would in effect bankroll the filing of the cases that would support the innovation that they had already done in their university environment. Unfortunately, the United States on March 16, 2013 is going to move into a new world from the first inventor world which we have occupied since the beginning of the Republic to a new First-Inventor-to-File world. This new First-Inventor-to-File world is going to create a huge demand for filings that are early and often. And universities just don't have the money to do these additional filings. So what does a university and tech transfer office do? I would submit that they need to create a fund to support these new filings from existing things that they are working on. And they need to bankroll these new filings so that they can produce very high quality patent portfolios early and often in the process before they have commercial vendors or entities on the hook to pay for this technology. In other words, they're going to have to bankroll these patent portfolios more than they've done in the past. Another issue that is very important, I think, for universities to know is the distinction between state universities and private universities. State universities may have sovereign immunity under the 11th Amendment of the U.S. Constitution, which gives them additional latitude in their licensing and enforcement efforts because they may not be subject to declaratory judgment actions to invalidate their patents. And there is a recent case that occurred against the University of Illinois in the federal court in Hawaii that brings this out. And this gets us to a new and very important development that has occurred in the tech transfer world for universities. And that is the new contested proceedings that have come into operation on September 16, 2012. These new contested proceedings include covered business methods and inter-party reviews. Now, many universities that I've spoken to are not worried about their patents being challenged in the patent office that they are engaged in licensing. And therefore, they need to reconsider that threat, because it turns out that of the 160 of these new contested proceedings that have been filed to date, several have been filed against several of the most prominent universities in the United States of America. So what does this mean from a practical point of view? These are very costly proceedings. They need to be very carefully taken under consideration and defended. Otherwise, the university ends up with a patent portfolio that has been destroyed in these new contested proceedings and therefore cannot be monetized in the typical fashion that universities have done in the past. So the summary here is that universities and technology transfer offices need to do a top-to-bottom review of their strategy and tactics and their business model to take advantage of these new developments that have occurred in the U.S. patent landscape under the American Invents Act. Thank you very much for the opportunity to present to you.